Hello, thanks so much for joining us at this Law and Place session with Amelia Thorpe and Sarah Trotter, where we're going to think about collectively how to research law and place. So obviously there's no right way, but when I'm thinking about how place is governed, I tend to think about the spatial settings, the rules, and by that I mean the legal and governance rules, the practices, the people, and what I've called the things, or we might call materialities, but also including habitats and other species. So places by their nature are often interwoven and quite complex, and disaggregating all these different aspects can be tricky. So that's what we try to do. So if we were to begin with legal geography and start working from the ground up and working with the setting, then quite quickly even, when we look at public space, we can see that there are quite distinctive settings. So we might be outdoors, we might be in a beautiful setting, full of joy, watching the sunset, finally released from lockdown, walking across ancient paths, breathing fresh air, away from people. So that would be one particular spatial setting, or we might be in an enclosed space, we might feel afraid, it might smell of urination, there might be histories worked into the walls. So by spatial setting, I tend to mean location, physical features, historical trajectories, how people have behaved in certain places, as well as social norms about how people should behave in certain places, and that tends to go to practices, so we'll look at that again below, as well as affect. And while location may not be that critical in and of itself, I think sometimes it can be significant. So in our interviews on public space in Bristol, in an urban context, one of the most problematic sites is described as follows by a cafe owner who was trying to manage the public space around her. So automatically in a half-mile radius of this site, you're looking at 37 services for drug users, the court, cheap booze, 49p a tin for strong cider one summer, the hostels, nightclubs, access to drugs, and lots of services. So she would see it as the social living room for many people, for a very diverse community. It was also a main through route to walk into the city for many people getting to the shopping centre. So the location, the particular services that surrounded it, really patterned this site as far as our interviewee was concerned. So sometimes the physical location itself can be critical. And sites can come with their own way of, their own sense of how we should behave in them. So there's a normative aspect which may not be legal, which may be cultural. So for example, in a park you might do a quiet sport like yoga or tai chi, even if there are no restrictions on sports. Now there might be restrictions on sports. I always think it's a sensible rule that there's no javelin throwing in most local parks. There are also attempts to restrict what was known as annoying football in Bristol parks that didn't go very far. But these spatial settings come with their own expectations and their own social practices according to the location. And also obviously they are green, they are quiet, they tend not to be polluted. So they are good spaces for people to relax, perhaps to inhale more deeply, and to enjoy themselves, so sites of enjoyment. In contrast, the problematic site that we've been working with is in an underpass. So one of the interviewees here, interview 6, who's a professional in this field, says, we've all been assaulted at various stages over the years, and it's sad that that's part and parcel of the space. So yes, that might happen on a normal high street, but you have fewer eyes on the space here, in part because it's below street level. So sometimes things get neglected and things happen in the shadows, particularly in the evenings, for example. So the spatial setting of the site can affect how the place is governed, because it enables people, for example, to hide and jump out at the last minute, or a park might be that a spatial setting means that there are lots of people there through different times of the day, and there's an expectation of communal engagement and getting on with each other, so people might be more likely to help. So spatial setting is part of how we govern space. So then, as a lawyer, that brings me to rules, and by which I mean legislation, guidance, statutory instruments, case law, anything that we might recognise as a more formal form of law. So including public order rules. There's definitions of public place for antisocial behaviour or dangerous dogs. There's work on public space protection orders in sociolegal studies, very good work by Kevin Brown or by Sarah in her piece on seagulls, which we'll probably consider in a minute, I hope. So public order rules would govern space, and administrative rules would govern space. So I've talked about something called spatial particularism, when you draw a line around an area and you call it into being both legally and spatially by giving it a name. For example, you label it as a park or a highway. And that calling into being both legal and spatial brings with it an often quite singular way of governing the space. So there is an image, a spatial particularism of the way in which that place is conceived, both spatially and legally. So for example, highways are mostly about flow. Parks are about a certain type of recreation, quite gentle sitting down, but not necessarily big festivals. So there are governance questions in administrative law that govern spaces, or governance assumptions, which I've called spatial particularism. Then we've got land law rules and the right of the landowner, which I spent quite a long time looking at and is in the other presentation if you're interested. And land managers and landowners in particular are very concerned with health and safety and insurance, occupiers' liability. So very much the responsibilities of land ownership, as well as the right to determine what happens where. So when we have a piece of land, it's always going to have an owner, and it's always going to be subject to the laws of tort or the laws of public order or criminal law. But yes, this idea of spatial particularism, there's a certain type of way of using the land that is envisaged in the legislation, so as a right of way, for example, as a footpath, and that if you were there to obstruct it, then that would not only break provisions of the law, but it also go against how the space had been legally conceived of, the spatial underpinnings for that legal definition. Which brings us to the third way in which law and place is governed, I think, which is through practices. And this is where sociolegal scholars, perhaps we feel most comfortable. So we can look at enforcement practices in respect of public order, the criminal and the traffic, landowner and land managers practices. So I've noted already potential liability for health and safety, and anyone else who has legal or governance authority over the place. So perhaps an immigration officer or a bus conductor. So there might be all types of people who have certain ability to govern, and their practices may differ. So slightly an implementation gap between law in books and law in action, but it's broader really these days, isn't it, about a legal assemblage, about how we understand governance in these broader terms. And as well as all of this, we have social norms and cultural practices, perhaps performing prefigurative work, as Amelia is now looking at using Davina Cooper's insights on this, trying to build a better world through action, and coming together with shared social norms, which of course raises questions about the relationship between law and society. To what extent are these social practices, and how do these coalesce into legal practices? So, for example, allotments are sometimes said on government websites, for example, to be open space or green space, and yet anybody knows who's ever looked at an allotment gate that actually accessing an allotment, if you are not an allotment holder, is just about impossible. And there are very clear social norms of governance that supplement the legal rules, the engagement with the council for allotment holders. So practices are clearly critical on how we manage spaces, whether or not it's a public space, but it's often easier to do when there are shared values and shared norms, and that might sometimes make the space a bit less public. And so there's more heterogeneity, more difference of opinion in public spaces. And in our conflicted site again, and I'm very aware that I keep using this conflicted site as an example, but it was where we were continually referred to by our interviewees when we were snowballing. Here, this is an issue where we had occupiers of the site, and there were some more politically minded squatters and some users of drugs and other substances. And the police officer, rather than use full policing powers, ended up pointing to the landowner and arguing that it was for the landowner to evict. So right at the end he says, there's not a lot we can do about evicting you because it's not our job technically unless the council want us to do it. But if you lot start messing around, then we'll get heavy-handed, as in we'll take the law. We'll use the law to get you out. So there's all about practices of policing, but ultimately it's for the council to evict. That's what he was saying in that interview. And the other way in which I think this shows that places can be governed is by people. So Amelia's work is thoroughly optimistic and forward-looking, and people welcoming other people in. So creating parklets, for example, on Owning the Street, to include people into public spaces, to make public spaces where otherwise there might have been a temporarily private parking space. And on the other side, again, of course, we've got this site where somebody is swearing or is so violent that people feel very uncomfortable in that site. And if a local cafe manager has to manage those interactions, it can be very difficult. So people can pull you in and people can push you away. And it might be violence, it might be teenage dynamics in a park, who gets to sit on a swing and who doesn't. There might be all kinds of ways people, or people dressed in a certain way. People are dressed very formally and you're dressed not formally enough, or vice versa. You may not feel comfortable. But people are clearly, through practices, their own practices, social practices, governing the space, and often intentionally trying to include or trying to exclude. And so last thing then is, the last way in which place is governed is to think of place as governance by things. This is also what I talk about sometimes as property as object. So things here very broadly conceived. So if we were talking about property, we might talk about, we teach adverse possession, we teach about gates and fences and padlocks. And we can see railings and we can see planters and we can see tables and chairs put out onto the pavement, whether or not the actual freehold or leasehold extends that far. So there's an enclosing of space through material objects. And one of the aspects when we talk to land managers about how public space is managed is how often materiality comes up. So this is a young man who was really young at the time he was talking about his job. So he was 22, reflecting backwards, and these kids wanted to come and skateboard, and he says, look, you know, lads, I know this sounds horrendous, but there's Chinese granite on the floor at Spinningfields Estate, and this Chinese granite slab, when you put your skateboards on it and scratch it and it has to be repaired, costs hundreds of thousands of pounds. So the type of granite chosen by the architects and the client will govern how the space is used for the next 20 odd years, because no one will be allowed to skateboard there. So the materials included in the construction are critical. This is also true about noise. Noise is one of the great ways in which public space is governed, and if there's not enough absorptive trees or grass or other softer substances, or we have channels built into large estates and noise echoes, then there will be much less freedom to behave in a way that might be construed as noisy if, for example, you're next to offices or residential areas. Again, materiality in this site with the urination and with the needles, and in a way governing the site through these practices so that no one else would want to be there. So if we see these as strategies of spatial governance, then one way in which space or place can be governed is by leaving unpleasant objects around that other people might not want to be around. And in that way you use material objects to exclude others. And we come to Sarah's work on seagulls because seagulls are so material once you start looking at public space. So I've always very much enjoyed this piece. And she concludes that the regulation of seagulls is to keep seagulls out, so that they don't harm humans. and suggests that by eliminating encounters and confrontations with gulls, there's a reduction in the publicness of space. So is it truly public if we are restricting gulls? Equally, is it truly public if we are restricting urination practices if there's nowhere, if no loos are open? Is it really public in that sense? Is it public if you're not allowed to drink outside? Conversely, is it public if you want to take your shirt off if you're a man, and women, particularly from cultures across the world, may find that offensive? So if truly public spaces where everyone and everything and every goal is permitted, that may also be exclusionary. So it's understanding how these aspects are managed in socio-legal studies. And this was a quote which reminded me of Sarah, so a public land manager. So one of the things we kept finding was we'd have the right to protest in Articles 10 and 11 of the ECHR, as lawyers would know well, but in practice, land managers get very upset about leaflets, and we find it hard to imagine why leaflets would be seen as so risky, so dangerous. But it's about liability, so that if you get a soggy leaflet and somebody slips, then there's a claim for liability. Or you've got to clean up the flower beds, or it attracts the seagulls and gets everywhere. So this is why leafleting is often restricted, even if it's allowed in legal terms, obviously, on land owned by public authorities, under Article 10 and Article 8 and Section 6 of the HRA, because of the material effects that protest or leafleting can cause. And one last aspect, which is that sometimes we may not know who owns a piece of land, and there may be a lack of materiality, and that may make governance difficult as well. So particularly in England and Wales, where we don't have a cadastral system, we'd have to know the address and look up the title numbers and do that one by one for a relatively small amount of money, £3 or so a shop. But once this adds up to millions of pounds if we wanted to really know who owns our city. And this lack of ownership that is materially evident when you're walking through a site can be quite difficult, especially then if perhaps it's held in corporate shells or behind a trust, and you may not know who the landowner is, and you may not know who to ask whether or not you can undertake a certain activity in public space. Sometimes there's a lack of materiality, which is also difficult. So, for example, a private sector land manager in interview 1, the estate around here, it's not all in our ownership. There are different ownerships, which probably your average pedestrian doesn't realise, that different bits are owned by different people or different bodies. So it's quite hard to sometimes know who the land belongs to when you want to do something in public space. And land manager 2 said, well, I don't know how people would know how to apply. They perhaps tend to contact so-and-so, and he contacts me and gives them my details, and I say yes or no. But there's often an email chain that may not always be obvious, particularly in the private sector, about how you might set up an activity on public land, even if you were prepared to pay for the insurance and get the permission to do so. So that lack of materiality also patterns our experience of public space. So that's just to conclude. I still have lots of practical questions that I'd love to discuss about site anonymity and about how we disaggregate these different strands of law and governance in space. Thank you so much for listening, and I'm very much looking forward to our discussion.